Bastian, and he is instrumental in putting this panel together and reaching out to all these attorneys across DC and across the country to make sure we have a good group of panelists here to discuss this. Our goal is to kind of have this discussion and bring in some experts to inform our public interest attorneys like ourselves on these serious issues. So logistics, we'll have some time at the end of the panel to respond to any questions from the audience. You can submit your question in the chat. But with that, I'll go ahead and introduce our panelists. First, we have Alex Alt. He's the Policy Counsel of the Digital Justice Initiative at the Lawyers Committee for Civil Rights Under Law, where he focuses on policy issues related to the intersection of technology and racial justice, such as consumer privacy, algorithmic bias, discriminatory advertising, and government surveillance. Next, we have Kevin De Liban, who is the Director of Advocacy at Legal Aid of Arkansas, where his efforts are used to improve the lives of low-income Arkansans in matters of health, workers' rights, safety net benefits, housing, consumer rights, and domestic violence. With Legal Aid, Kevin led a successful litigation campaign in federal and state courts, challenging Arkansas's use of an algorithm to cut vital Medicaid home care benefits to individuals who have disabilities or who are elderly. And lastly, we have Enid Zhao, Senior Counsel at Electronic Privacy Information Center, or EPIC, which is a great name, where she oversees the Open Government Project. Enid's work focuses on FOIA, and she litigates open government cases in federal district court. Enid also co-authored Screened and Scored in the District of Columbia, a report where EPIC spent 14 months investigating the DC government's use of automated decision-making systems with the aim of providing a comprehensive view of how these systems shape the lives of district residents. With that, I'm excited to turn it over to Bardia to get us started.
Everybody, so Sebastian and I are going to alternate asking a series of questions. We're going to lead off by asking Enid. So basically, we're going to just start at the beginning, and we're going to ask the first question is, can you explain what an algorithm is to the audience?
Yeah, sure. So I would describe an algorithm as a sequence of steps that are followed to perform a certain function. So I often describe it kind of like a recipe. It uses computational or mathematical formulas that use data as its main ingredient, and it uses this data to produce something like an output. And algorithms are actually included in a broader umbrella term that can be called automated decision-making systems. And that is something that we've highlighted, EPIC has highlighted in our Screened and Scored DC report, in which we were looking at automated decision-making systems as a whole within the DC government. And automated decision-making systems are actually data-driven or rules-based approaches that basically replace or inform human decision-making. So they can range from using algorithms, or they can range from using simple score sheets or actuarial tools or machine learning models, AI, statistical tools, and also risk assessment instruments. And it takes certain inputs, so it takes data. It runs that data through a statistical model of the world, and then it produces an output, which is a decision. And so these automated decision-making systems, they can generate things like scores, they can generate predictions, they can generate classifications, or even recommendations that help in the human decision-making process, which is both in part or in whole.
Thanks, Enid. And what are some, you've mentioned a couple of circumstances, but what are some common circumstances in which these algorithms are used? And why should the average consumer or DC resident be concerned of how they're used?
So automated decision-making systems have different levels of complexity. Like I mentioned, it can go from score sheets to machine learning, and they use a wide variety. So they're used for a wide variety of tasks. So for instance, public agencies could use a simple checklist. So they can determine which members of a homeless community gets priority for resources. Or you can have an algorithm that can assign children to certain schools within a certain region. Or it could help make policing decisions on where to patrol, whom to target. And it can get really complex in terms of the system to incorporate machine learning that can identify fraud in the unemployment context. And then not only government systems use it, but private sectors use it too. So you can, think about banks determining when you can qualify for a loan, or even when like Netflix determines in your algorithm what should you be watching next, whether insurance claims, whether they approve it or not, or the DMV should be whether you should be fined for your driving habits, and can go from like medical decisions like whether you get a kidney or not. And also, I think a lot of us, it's very common nowadays too. It's most people kind of run into the issue of when you're doing background and credit checks is whether you're approved for housing. And a lot of times you can kind of run into background check systems that use automated decision-making systems. And then it basically touches all points of life. So it could be in the criminal justice system, it could be used in healthcare, it could be used in housing, all over.
So we often hear about how algorithms discriminate, that it can make faster decisions, but not necessarily fair decisions. Is there a concern about this? Is there a concern with that? Basically the scaling issue?
Yeah, I think that people really should be concerned about it, because a lot of times it's making decisions that alter the path of people's lives. And oftentimes you just don't know that it's happening or how a decision is even made. And oftentimes when they're left in the dark, people really should deserve to know whether these systems are accurate, fair, unbiased, and oftentimes they're really hard to challenge too when you don't know that it's happening to you.
How would you describe, like, what would you say to somebody who's, who acknowledges that people are inherently biased based on, racial institutions, et cetera? What would you say to them if they said, well, this is a computer, this is AI, does that discriminate on disability, race, or age?
Yeah, I think people often give deference to these tools and think that there is an objectivity to the decision, but these tools do often reinforce bias and discrimination because it comes from choices and assumptions from the ground up. So based on who built these systems and based on the data that is used. So a lot of times these systems are trained at recognizing what is normal, and they look at historical data or data that's been collected out of in the context of oppression or discrimination. And oftentimes when you're making the data itself could encode inequality into its decision-making system, and it makes it more likely to discriminate and deepen inequality. So one example I often use is when an automated decision-making system is like denying applicants for housing, and often they deny it based on things like criminal records or poor rental payment history or a history of eviction. And a lot of these negative decisions disproportionately impact people of color or people who are victims of domestic violence or people with disabilities as well. But the discriminatory aspect of the system is also, it comes from how and when they're used. So one, it's the way that they're created and how they're trained and the data sets they're used, but it also comes in how they're used. So for instance, lending institutions will often use algorithmic tools to target people in low income communities, or police and law enforcement will use things like ShotSpotter or automated license plate readers to put them in places that are primarily poor or minority neighborhoods that are often over-policed in the first place. So those are just like some ways I'm thinking about how they discriminate.
Sebastian, you want to take the last question?
Sure. So you mentioned when an algorithm discriminates, it relies on that information that was put into it, whether it's, these assumptions or, another source. And you had previously mentioned machine learning. Can you explain kind of how we can combat that? Are there ways to curtail that in the context of projected applications?
Yeah, so I'd really like to be optimistic in terms of thinking about ways that we can combat that and fight back. And I think that there's a lot of things happening that are increasing transparency, oversight, and also combating bias, both from organizations like Epic and lawyers committee and others at Upturn and things like that to like people who are serving populations and also those who are affected. So from the individual perspective, I'm going to plug the Benefits Tech Advocacy Hub that's developed by Kevin and folks at the National Health Law Program and Upturn, where individuals can request fair hearings to appeal an adverse decision, for example. And the Benefits Tech Advocacy Hub just gives advocates a tool to really fight harmful benefits tech. And that hub in particular will give you questions that you can ask yourself and ways that you can identify when an automated decision-making system is coming into play, steps that you can do to challenge it, such as asking for a copy of your score or profile to see if there's inaccuracies. In terms of Epic, in our screen and score report, we talk about how that there's more, that the more information that we share with each other, the more we can understand how it impacts our lives and communities. So I think collectively, like advocates, people being subjected to these systems individually, policymakers, I think collective organization is really helpful in raising concerns, having panels like this and talking about it with other people who may not understand how this tech is impacting them, impacting their clients or the populations that they serve. And again, plugging Benefits Tech Advocacy Up. They have models for tools and how you can use to combat something like this. And then also highlighting stories. I think it's really important to talk more and highlight stories about how communities are challenging these systems and also winning, because it is very possible. So I remain very optimistic.
Thank you so much, Anit, for your analysis and your input there. It was really wonderful. One of the questions that I had, though, to tease out was you made a mention about oversight and collecting data. Something that I think that I've seen in my line of work is that sometimes when somebody gets an adverse decision, they don't even really know about how to go about challenging it. Do you think that there's maybe possibly a timing issue that is curtailed with making everything more transparent?
Do you mean a timing issue in the adverse decision or
in the sense of protecting due process protections and allowing for that issue to not be mooted or giving somebody the time to respond to an adverse decision?
Yeah, I think a lot of times people, so there's like multi-prongs to this, right? Where sometimes the appeals process is very long, it's complicated, they don't know how to do it even, or sometimes staff is underfunded and under-resourced to address it during the appeals process. So I think that that's a big issue where when you are having an adverse decision, challenging a determination, is to know when, at what point an algorithm has made an adverse decision, and how do you even know what the decision is? And that's a big challenge, I think, that not everyone is equipped to handle. So I think that there is a large transparency issue that should be resolved, and government agencies should be rather proactive about that. And I think that's something that we found in our report, is that it's not very comprehensive. Some agencies didn't even know whether or not an algorithm was being used within their program areas. So, yeah.
Thank you.
Thanks. So now we're going to turn our attention to Alex. And of course, our other panelists can contribute as well. But before we get into the pending legislation that's before the DC Council, I'd like to ask generally throughout the country, Alex, if you've seen any other jurisdictions utilizing legislation to combat algorithmic discrimination.
Yeah, so I promise I'm going to answer your question, but I'm also going to first generalize just a little bit more, so that, because I think that, you know, when we're talking about algorithms, we're talking about the input, which is data, and we're talking about, you know, the output, which is the determination, right? And so I think when you're thinking about how legislation addresses all of this, one of the important aspects to kind of, I think, lump in this group of potential solutions is privacy protections, because how data is collected is really, really important, along with being transparent about how algorithms function. So when you look at like different jurisdictions and their approach to combating this, there are some direct bills targeted at what are the algorithms doing, how can they be transparent. So for example, there's the Algorithmic Justice and Online Platform Transparency Act that Senator Markey introduced, I think first in 2021. And there's a lot of state approaches also that focus mostly on trying to make clear when an adverse decision has been rendered, or give some sort of audit report to a state authority that would let them know how companies are using algorithms. But there's also all of these different state approaches, a kind of patchwork of privacy laws, because there is no federal standard of privacy protection. There's some sector specific laws, but there's no universal, here's how to collect, here's how to sell, here's how to transfer data, here's what you can collect, here's a proportionality requirement. None of that really exists. And so what happens is companies especially, but also the government, have an incentive to collect as much data as possible and use it in all sorts of ways, kind of using us as guinea pigs. And so we have seen an explosion in both legislation addressing privacy and legislation addressing, the end result of algorithms, because I think Americans, especially over the last 10 years or so, are really starting to see how all of that data collection is starting to affect them. I mean, we've all experienced like something that used to be just a service online that now wants you to use their app. And the reason they want you to use that app is because they can collect data better on you, right? And we've all seen targeted advertisements come to us when we weren't aware that they had that information about us. And so, when we're talking about legislation that combats this, I think it's important to think about how do we kind of open the hood on what ingredients, to use that as an example, are being used in this recipe, but we're also kind of careful to be like, what ingredients can we bring into the kitchen, and who's cooking, and how are they, going to plan to use all of this? In some cases, the genie is out of the bottle a little bit. So much data has already been collected that we have to focus on the algorithmic processes themselves. But we should also be really cognizant of how data is collected in the first place and trying to manage and minimize that collection.
For sure. So in terms of local DC legislation, the Stop Discrimination by Algorithms Act, or the SDAA, was introduced for initially in 2021 and then more recently earlier this year. Can you talk a little bit about that, Alex, regarding what exactly does this bill do, and how does it affect covered entities? Does that affect DC government? Does that affect any company within the district?
Yeah, so let me try to talk about what the SDAA, the Stop Discriminating Algorithms Act. I'm sorry, even though I do this for a living, I still trip over the word algorithm. So it's not uncommon if you do it too. But so the SDAA does three important things. It bans discrimination for use in protected traits like race or sex or disability in automated decision-making about important life opportunities. And when you think about important life opportunities, the definition of that is basically like education, healthcare, will I get this job? Will I receive these benefits? That type of thing. It also requires companies to audit algorithms for discriminatory patterns in their algorithmic results. Now, that sounds like a bunch of mumbo jumbo, but here's why that's important. There are laws on the books, especially in DC, about prohibiting discrimination. But so many of these algorithms take data from the real world that may or may not have racial bias in it, and they follow the steps, and then they produce something. And so sometimes the algorithm itself will be biased or produce discriminatory outcomes that even the people who are building the tool, the algorithm themselves, are not aware. Now, when companies have to audit algorithms, they have to look under the hood and check for bias. And that's really important because right now, the incentive structure is not to do that. if you can be sued for discriminatory conduct and you know it's discriminatory, there is something to find in discovery. If you simply don't look at it, you kind of have a default shield. And that's a really bad dynamic. I'm not a litigator, and I know that we have some litigators probably in the audience and also on this call, but like that seems dangerous. And it seems like one of the STA provisions of requiring these audits is an important tool to kind of fact find in that setting. The other important thing it does is it bundles all these audit results and any corrective steps that companies have taken and sends them to the Office of the Attorney General. So there is some sort of oversight in terms of what companies are doing. I'm always a little skeptical of any sort of privacy bill that puts all of the final onus of protecting on an individual. Like we've all just clicked through things online about, yes, accept the cookies, yes, give away my data, because like it's just unacceptable when we're just trying to get something done. And so I do think it's important to kind of have a two-pronged approach. Then the third thing that the SCA does is it requires disclosures and explanations when an algorithm negatively affects an important life opportunity. So if you are denied that job or that benefit or that kidney, you are given a like one-time plain language notice, hey, we used an algorithm, here's what it did, here's why you didn't get it. And so that's sort of a foundational building block of then making companies disclose, letting the individual be empowered to challenge that determination, and for just I think litigation in general and the incentive structure of making sure that companies are testing this stuff before they're deploying it.
So Alex, just to follow up on the SDA a little bit. So compared to some of the other mechanisms to combat discrimination in DC, do you think the SDA provides an additional private or a cause of action for a plaintiff? That maybe they would...
Definitely. So it does. So yeah, I think that there is one type of argument would say, DC has this human rights law, and that human rights law has a private right of action in it. Why do we need another law or this special sort of subset? And it goes right back to that like kind of popping the hood example that I gave before. The SDA bans discriminatory use of protected traits and automatic decision-making about important life opportunities, right? Algorithms rely on those personal traits. They literally use data about who you are to determine something about you. And what the SDA does is sort of identify and fill a gap in the law here, because, when you have a general discrimination provision, you have to know that you were discriminated against in the first place to prove that claim. And so without sort of a notice, an audit, a transparency, it's much, much harder to identify discrimination, particularly when, the deployer of this algorithm might not even be aware it's discriminatory in the first place without this legislation. So it does have a private right of action under it. And that private right of action includes, violating the statute by like not auditing your algorithm before you deploy it, or not providing notice that an algorithm was used when you're, doing this important life decision. And so it broadens it in a way that makes compliance sort of this regime where you have to look into what you're doing. You can't just ignore the consequences anymore.
Yeah, so Alex, I mean, this bill seems like it requires companies and covered entities to be transparent when they're using these algorithms, or to audit or to even discriminate. But does this also prohibit discrimination when denying someone important opportunities such as employment or housing or pretty much any circumstance of life?
Yes, I think, there was a question mentioned by Barty about like, does this apply to the government? And I think that's what your question is getting to. And the answer is, I don't think so, but I think that's open to interpretation. The bill sort of uses this language about any legal entity, but then it has a lot of other provisions that kind of make it clear that this is directed at companies. So it's a matter of statutory interpretation. My best guess is it does not apply to the government, but I think you could make an argument that it could. You know, the definition that it uses is covered entity, and it lays out, you know, all of these steps that you have to have, you know, a certain amount of personal information on more than 25,000 district residents. You have to have greater than 15 million in annualized gross receipts. Like any of these things could trigger it. And the government would, and the government does make important determinations. But the controlling language is that a covered entity would have to be an individual, firm, corporation, partnership, cooperative, association, or any other organization, legal entity, or group of individuals. Not any sort of explicit hook for the government, but kind of unclear language that could be debated. The rest of the bill seems to focus mostly on corporations.
Yeah, that was of really particular interest to me. Just the idea of whether or not the gov agencies would be covered under covered entities and why that wasn't spelled out pretty explicitly. One of the other things that you mentioned, however, is that they're required to aggregate that data, and they're only required to furnish it to OAG. Do you think that there would be some value in maybe making that information publicly available so that, you know, third-party entities such as an Upturn or an Epic could maybe have more access to the data to audit it kind of individually?
Yeah, I mean, look, gut answer is yes. The real answer is the devil's going to be in the details in terms of what the OAG does, right? I mean, like all enforcement regimes, you're going to need resources. You're going to need to be transparent about how you're enforcing this. And so there's a world in which this wouldn't be needed. But as a member of civil society who works at a nonprofit that looks at these sort of things, I always want to err on the side of like, yeah, protect individuals' privacy, but like, you could aggregate these reports and let us know, you know, if X company is only showing this ad or making this adverse decision to people of a certain type of characteristic, that should be a thing that, you know, we can look at and use to our advantage in terms of like pursuing enforcement beyond just relying on the OAG to do it all the time. But like I said, the devil's in the details, and I want to make sure that, you know, with these type of laws, that we get a chance to walk before we start to run. Because there are real privacy concerns about passing along information, you know, meant for one entity to then be accessible.
Thank you.
All right, now I'm going to turn to my fellow litigator, Kevin. Kevin, you've had a ton of experience in litigating in this sphere. Can you explain how you came to be familiar with algorithms through your litigation work?
Sure, it's fun to sue the bastards, right? So I'm a frontline legal aid provider and have been my whole career, which now is about 12 years. I guess the era was technically 2014. My program did not have a long history of doing extensive Medicaid work, but we've been getting more and more involved in that. In 2014, we started hearing from clients who'd been on, so Medicaid is a super complicated program, but one aspect of it is something called home and community-based services. And basically, each state or entity, like DC, has the opportunity to provide a sort of augmented set of services so people can stay in their home and not have to live in an institution like a nursing home or something like that, right? And they can provide these services through a program that's not super important, but just so you have some context, it's called a waiver. And what that does is just limits, it allows you to limit as a state the number of people you're going to serve through this program. So you're not going to help everybody avoid institutionalization, but you know, whatever number of people you decide that you can do within your state resources. So we've had this program for a long time. We had very few, if any, calls about it. Suddenly in 2014, 2015, we got a dozen, 2 dozen calls. And what happened is people who had been on the program a long time were suddenly being told that they were no longer on the program at all. They didn't qualify. And one of the most absurd examples of this is a client of mine who was paralyzed on one side of his body. And they determined that he could do the required activities of daily living so that he no longer needed to have the program help him with in-home care. We started seeing this then, and we found out, oh, the state has just switched to a new assessment tool. But that was about the extent of our knowledge. 2016 is where it really came into focus. And what happened is we had floods of calls. I mean, like probably in the year 2016, 100 people called us, something like this, maybe more, who were suddenly saying, my benefits are being cut. So we have, for example, people with quadriplegia, people with cerebral palsy and multiple sclerosis, folks who have conditions that do not get better. And they've been receiving for many years 6, 7, 8 hours a day of care that were suddenly getting dropped to 3 or 4 hours a day of care. And what this means is just abject human suffering, people lying in their own waste, people getting bed sores from not being able to turn or be turned, people being shut in and totally isolated from any sort of outside activity or community involvement, just human suffering on a just enormous scale. And that's kind of what prompted us to start looking into things. We figured out, oh, what the state had done actually is that assessment tool that they switched in for a couple of years had been using as sort of a limited pilot and was just connected to algorithms determining eligibility. What was new in 2016 is that they were using algorithms to determine the level of care that you got, the amount of hours of those in-home services you got. And so that's kind of what led us on to a big litigation campaign, and sort of why I'm here today is just it's taken me along this path.
So just to tie together some of the commentary from the other presenters. So would you say that there was an issue both with the tool itself and also the way that they were inputting the data, or was it simply the tool itself?
No, it's all of the above. So one thing to keep in mind with all of these things is that the algorithmic decision-making systems or AI, however we're, there's some nuance there, but this general broad category of tech-based decisions that we're talking about are generally implementing policy choices, right? So there's a question of, is the problem the policy or is the problem the tech? And sometimes the answer is both. And that was kind of the situation in our case. Is the state had decided they wanted to save money by cutting services to home and community-based services, people receiving home and community-based services. So there's a policy problem, but then there's also the tech problem. And then there's the oversight of the tech problem. So the tech problems were terrifying. So the state used bad historical data about usage, right? How many hours of care people had gotten historically. That was then lost by the consultant company that had calculated the data. They couldn't find it. They had done no pre-implementation testing, either about how people would be affected, right? Are people on the program who have particular characteristics like cerebral palsy, are they going to be affected in a particularly helpful or negative way? No pre-deployment testing. They didn't do basic code review. So once they implemented it, the software was broken. So the algorithm wasn't even working as the algorithm was written. Another aspect is that the algorithm as written and as it was supposed to work ended up providing totally insufficient levels of care for people who needed it. So there's just this whole, what wasn't a problem, right? It was everything.
Do you think, in your opinion, though, that an algorithm could be utilized in a partial determination for a level of care, or do you think that having a doctor actually go and do a health analysis on somebody's level of home health care would be a better method? Do you think there's a way to integrate this so it can be positive?
I always challenge the premise of that question, Barty, which is that these are never being implemented to augment people's benefits. It just doesn't happen. So I always challenge the premise of the question. There isn't anybody who's ever going in that way. So don't even accept it. Like, never, if somebody asked you that, oh, why don't you help us make us better? No, because what it is it's going to lead to cuts.
Because one of the concerns obviously is cost neutrality, right? So the home health care program has to be on par with the nursing home level of care for the facilities. So I think that what you're saying is probably pretty accurate, that this isn't really a tool to, as you said, expand people's benefits. And correct me if I'm wrong, I'm assuming that you saw a large level of cuts once that new tool was implemented.
Yeah. I mean, the cuts were horrendous. So the state wasn't even tracking data on how many people got cut or benefit increases or stayed the same. They had to hand assemble it after we sued them. But what it came out to is at least that half of the people were getting cut, roughly half the people were getting cut. The smaller percentage was getting bumps, but what we knew is that the bumps weren't very significant and the cuts really were. And again, the human devastation for anybody, like I had to learn a lot about in-home care and whatnot. Arkansas's maximum prior to the algorithm was 8 hours a day of care. Now, that's not generally enough for somebody with cerebral palsy, multiple sclerosis, quadriplegia, various other things. But if it was deployed just right, you had 2 hours in the morning to help somebody get up. You had 3 hours in the afternoon to help with activities and food and like cleaning. And then you had 3 hours at night to help somebody get to bed. If it was deployed just right and you actually had caregivers who would come and would show up and all of those things, it was enough to live independently. You take any one of those hours out, it's devastating to somebody. You take 3, 4 out of every day, it's terrible. And even for people who were starting out with less care, maybe 3 or 4 hours a day of care, you take 1 or 2 hours away and it's devastating. People are going without meals. They're choosing not to drink after 6 p.m. at night because otherwise they have to pee and lie in their own pee for a night until the next morning. So I'm sorry, maybe I got off on a tangent, but those are kind of the human consequences of those algorithms, and that's kind of how it played out in terms of the state not keeping even data about how that was going to be, how it was going to affect folks.
Thank you so much. Sebastian, you want to ask the next question?
Sure, Kevin. The idea of litigating this, it kind of stresses me out, to be honest. Well, not necessarily more than any other litigation, but what are some lessons, takeaways you learned, to maybe pitfalls and obstacles you encountered to maybe educate some of our litigators if they're looking to bring similar lawsuits?
Sure. We didn't know the full scope of the issue when we were going into it. And I think for those of us in direct services, there's a certain boldness that you get from having to help, and you dedicate your life to this, but from wanting to help so many people and having to do it, right? You know that you're not always going to have the perfect client. You know that, you can make your own luck in certain circumstances, right? And I feel like people who are less connected to direct services sometimes wait a little bit more. They want that perfect client. They think themselves out of the idea that something good can happen. So one of the things I would encourage you is having that gut, like this just feels wrong, right? Like that, this just feels wrong, sort of fire. And if that's ignited in you, then you just kind of have to have the courage sometimes to charge forward. Now you have to do it smartly, right? You have to know that you have a solid legal claim. You have to think about how you're going to get the proof you need. You have to think about how the state is going to respond when you sue them, whether there's a chance for talking it out or whether it's going to have to go all the way to judgment. You have to think about what the costs are. There's all those things, but I would say to start from a place where just kind of start from the outrage. The lessons learned, hopefully you won't have to learn them the hard way like we did, because there is help out there, right? Like I had to learn the algorithm. Like I taught myself like how to read the code and put it together with the assessments so that eventually I could tell you with a given assessment what it should generate. You don't have to do that anymore, right? Like there's organizations like our friends at Upturn that might help you with that. We have the Benefits Tech Advocacy Hub, which Enid so kindly plugged for us. That's a collaboration between ourselves, Legal Aid of Arkansas, Upturn, and the National Health Law Program, where we have a lot of resources. So a lot of those kind of lessons that you're asking about, we've tried to translate into action. Like let's share the knowledge with everybody, and we are all happy to talk to you individually too about a particular case. And I know a lot of folks in DC we've talked with a lot of folks in DC about the kind of inter-RAI algorithm that's at issue there.
Sure. So like so as far as the lawsuits that you brought in Arkansas, there's no SDAA version in your state. So under which, can you talk a little about the litigation? Under which statutes or regulations did you bring the lawsuits?
So constitutional due process was our first federal claim, right? And that was on notice and ascertainable standards. The idea being that the government has to have discernible standards upon which they're making a decision. And then they have to communicate those standards to you, right, through adequate notice. So that was the initial lawsuit. We prevailed on the notice claim, which was great. Then the state didn't. The other thing you could consider there is the Medicaid Act has kind of its due process statute stuff, but there's a question of private right of action in Medicaid. In the Eighth Circuit, where I'm at, there is no private right. The Eighth Circuit has ruled that the Medicaid Act is not always privately enforceable, including provisions that were thought that way. And the Supreme Court's deciding a case that might address that called Tlefsky, and the decision could come out any minute. So you've got the Medicaid Act potentially. You've got the ADA, like Olmstead claims, but those are pretty hard to substantiate, and they're getting harder, right? And then, so that's kind of thinking federally. You could consider other anti-discrimination things, but if you look at any discrimination jurisprudence, it is not hopeful. And one of my takeaways, and maybe we can talk about this more, is that the focus shouldn't just be on eliminating bias and shouldn't just be on existing anti-discrimination regimes, because in terms of private enforcement, those are tough hills to climb. State-based claims is another place to look. And our second case around the same algorithm was a state-based rulemaking claim. It was our Arkansas's version of the Administrative Procedures Act. And we basically convinced the judge and the Supreme Court of Arkansas that that the algorithm was a rule and it hadn't been promulgated appropriately under notice and comment rulemaking. So we won there. Also, one last thing to be kind of lesson-wise to Sebastian's question is pairing litigation with public engagement is key the whole way, right? Because what you can get in litigation might be stopping something, putting something on hold, but you're not creating a just system. And also we have to be skeptical of what the courts are going to give to, representing the good guys, so to speak. And so it needs to be paired with really thoughtful and not top-down community engagement and hopefully activation.
Sure. So as far as you mentioned several local and federal regulations you used to combat that algorithm tool in Arkansas, is there anything kind of turning back to the SDAA in DC that's pending? Is there anything you wish you would have had in your litigation that would have aided it?
Yeah, so one thing that I was, I'm cautiously hopeful about the SDAA for, if it were to apply to government entities, is explicit money damages that might be able to get over. I don't know how sovereign immunity works in DC, but for us in suing our state Medicaid agencies, there's no money damages available because of sovereign immunity. That can be statutorily waived, right? But there's a lot of issues around that. I think money is one way to help change the incentive structures. Because remember, everywhere you're operating, assume that the algorithm is going to be a weapon to enact some sort of policy restriction. You can go and get your injunctive relief. You can invalidate things. You can make life difficult for the agency. But what's going to change the incentive structures so that they don't just go and do something terrible again? And this is where we've litigated a case to seek to get through qualified immunity. We sued our state Medicaid officials in their individual capacities over due process failures for the system that replaced the inter-RI related one that we got rid of. And we were successful. We prevailed at the Eighth Circuit. And we're hopeful that that's going to lead to some pretty massive good news for our client community. So when you're talking about the existing legislation, money, I saw the damages are capped at 10,000, maybe you can get emotional damages or punitive damages, et cetera. Things like that I think will change it. Again, don't rely too much on transparency regimes. Those are helpful, and notice is a great thing, but at some point it can be fixed. Something beyond discrimination, I think also has to be in there. To get, and something beyond discrimination and transparency, essentially.
For sure. And as far as when I think about these algorithms, especially in a health context or public benefits context, I really get the impression that they're trying to use it to a very complex human aspect and kind of bring it down to a score or a number or some kind of simplified outcome. And Enid, you talked about earlier about there's kind of like this deference to these algorithms because they seem to be objective. So my question, Kevin, is is there a way to sort of ensure these algorithms can aid processing these health benefits applications, not necessarily being a primary decision maker, but maybe
So it's interesting when algorithms are replacing discretionary decisions, it's kind of different than when algorithms are automating processes. Like you can imagine like automated tax returns, right? Or now for those of you who are familiar with Medicaid, there's automation is being worked in the massive Medicaid redeterminations through this so-called unwinding process in the wake of COVID protections going away. When you're talking about that discretionary stuff, it's interesting because Enid's point is right on. Like it's so true. People defer to the algorithm, and it's to the point. I don't know if this is ontological or epistemological. I don't know, but the algorithm becomes the thing. So what happens is somebody's care needs, for example, right? This is something we should be able to measure. We know how much time it can take somebody to take a bath, right? Or how much time it might take to prepare food. That didn't matter in the administrative hearing process. All that mattered was whether the inputs to the algorithm were correct. So if you wanted to challenge the decision in an administrative hearing, you didn't argue that the algorithm gave this person 32 hours of care and we have all this evidence showing that they actually need 48. That's not how you argued. You had to argue that the assessor who filled out the assessment got one of the key criteria wrong. They ask you 286 questions. Only 50 or 60 of them end up factoring in the algorithm. So you have to show that the question they got the question wrong and that the question was one of the key factors in the algorithm. And so then your whole thing has shifted, right? The algorithm has become the thing that otherwise is measurable through common sense. So when you're talking about that kind of discretionary decision as humans review, I'm very skeptical of the algorithm's place because what they're going to be doing is shifting that frame so that it's not whatever you're trying to get at that should be observable. It's now this whole, it's what the equations say.
So I got one more question, Kevin, and typically we know the outcome of, as a result of using the algorithm. We don't often know how it is designed or how it works. Have you encountered through your litigation, these third-party companies that design the algorithm and sell the product, whether they're claiming it's proprietary and that's not allowed to be disclosed during discovery and litigation?
Yeah, this is I'll share my experience. I imagine Enid has a lot of insights into this, having to litigate the FOIA stuff more. So vendor liability, and that means either monetary liability or shame, pressure, et cetera, is, I think, the next front in a lot of our advocacy or where we need to be going, right? Now, in our case, it's actually a research institution called Inter-RAI, which is like, these are all doctorate level people who are interested in measurement and these things, and they've got this worldwide system where an Inter-RAI assessment is in Nigeria and in Belgium and in Japan and in the US, and you should be able to compare, kind of the datafication of all of this stuff. The idea being that an assessment in one place should be giving us the same substantive information as assessment compared somewhere else. Now, they're at least purportedly committed to science, right, in this way. You have tons of vendors who don't even have that basic supposed commitment to science, where they're happy to just build and sell terrible things that'll get you to where you want to go, right? Like the Idaho litigation is one example of that. I don't know if y'all are familiar, but it's this case brought by Richie Epink, who was with ACLU of Idaho, who was a huge help in my case, where the state just built an algorithm on its own, right? That was in an Excel spreadsheet. Vendors is there. We didn't have to face the proprietary questions. We were able to get the algorithm through discovery. We also have a Supreme Court of Arkansas FOIA case that we litigated. My colleague Trevor Hawkins at Legal Aid of Arkansas was lead on that, where we got access to information about unemployment fraud detection algorithms and how they were used. And the state was justifying withholding those on grounds that it was like a criminal investigation and other exceptions to FOIA. So we probably haven't had to face like a managed care entity saying, no, we are not disclosing our proprietary algorithm to you. There's thoughts that we have on how to get through that, but I'd defer to Enid more on that question.
Sure, I'll go ahead and turn to Enid on one.
Yeah, I'll jump in on that. So we have not done as deep of a litigation focus where it comes to the point of discovery to fight for some of these, like knowing what these black box algorithms are. But from a we do a ton of FOIA requests, and from a requester side, you see it all the time that they're doing exemptions on claiming that these are trade secrets, claiming that they're confidential. Or even especially when you are doing open government records requests, like a lot of agencies are saying, oh, we don't actually have the algorithm that we could show you, or it's not a record, or things like that. And they don't want to disclose it. And I think that's the one issue too, is when, even if we were to try to increase transparency and letting people understand what goes on in the black box algorithm, it's hard to interpret. A regular person, or most of us, probably wouldn't understand how the inputs and all the different types of logistics work without someone who is actually an engineer or some sort of someone who understands how the system was built. And so a lot of times, like, our organization is always pushing for things like audits, and from third-party audits in particular, who are experts in understanding whether or not these systems are accurate and fair and unbiased and are working properly. But there is often a lack in laws and agency like procurement guidelines to implement these types of audits as well. And I feel like it's hard to prevent agencies from using algorithms nowadays, but I think like trying to tackle it from a procurement standpoint, or at least from an auditing standpoint, and publishing those audits and making sure third parties and the public can actually read what goes on, and that the audited interpretation and things like that, to see if it is actually accurate, is actually really helpful compared to giving all of us access to the code, which we actually probably will never get because they shield it like crazy.
Thank you. I just have one follow-up for Enid. You mentioned something earlier that potentially keeps me up at night, called machine learning, where
Yeah.
the algorithm kind of creates these correlations. For example, if for an employer in the workplace where they're toxic towards a certain demographic, and then that demographic, as a result of that toxicity, quits, and there's a big turnover in that office, and the algorithm associates with that demographic to future job applicants, and maybe will reject that application based on that statistic. Can you explain a little bit more about machine learning and why we should be mindful of that one?
I think a lot of times machine learning tends to be the definition gets over conflated with like AI and things. It's really complicated, and even myself, it's hard for me to understand because I don't have an engineering background for it. And so I think what you're trying to get at is that they're using algorithms and automated technology. It could be a form of machine learning to create decision-making outputs that connect certain like factors for one thing. Is that so? Is that the thing that keeps you up at night, or? Or like, what is it? Can you rephrase the question?
Sure, sure. So I'll give an example. So say that there's an employer and the workplace was full of harassment towards women. And as a result, there's a big turnover in the workplace from female employees, so that the algorithm that processes job applications gets an application from a female applicant, and then it kind of interprets that as saying, well, this statistically, this worker is more likely to quit after X amount of time, and as a result, will kind of penalize the application or even reject it. I think as far as the machine learning, when it goes unchecked and it as a free for all forms these correlations and then produces the outcomes as a result.
Yeah, definitely. It goes back to my previous point about data sets and how you're training some of these algorithms in making those types of associations. It's the same as when you're doing screening, employment screening or hiring algorithms and thinking about names or like keywords for a certain resume, and you're just looking at what is historically the company itself has, or the training data has says what would make a successful applicant, or what would be someone that is like promotable or whatever like that. And we're using that historic data to make those associations and assumptions to say, okay, well, that person is more likely to be like more likely to leave, or more likely that you should hire this person because they're more successful over another candidate. So for me, I think of it a lot in the terms of thinking about what types of data sets that you're using to train to make those assumptions and associations. And a lot of times the algorithms that you are using in those types of tools are using kind of like dirty data, or like very selective data sets that are often biased, and will like put in those kinds of disparate examples and things like that.
So, Annie, maybe you can answer this, but I remember reading in the upturn testimony to the DC City Council, they were discussing about how some landlords are using RentGrow, I believe, as a third-party vendor that pools evictions and such. And primarily, I think the end result is that it has a discriminatory impact on DC residents in Ward 7 and 8. Are you familiar with how they make those determinations and kind of, I suppose, what could be done to maybe privatize some of that data or do some record sealing in the district, or to maybe combat?
Yeah, that's really hard because private landlords will use RentGrow or other tenant screening algorithms, and then also the DC government does that too for their public choice housing voucher program as well. And so from the agency perspective, you can implement laws. You could implement like something like the SDA to kind of, well, no, I mean, you can implement things that about how a government agency can procure certain tools and whether or not they can use them. But it is really hard for private actor, like tenants, landlords, to not rely on those tools, because most likely they all do, and they use it in conjunction with your credit screening reports as well. So I think I don't have like the best answer to that too, because sometimes you do need housing. And I know myself I've been screened and scored through not RentGrow, but something similar to find housing. And it's something like I couldn't get out of it either.
Mm-hmm.
But I think a collective action could be very helpful.
Just generally, are there other examples of the DC government utilizing algorithmic decision-making?
Wow, this is a great way for me to plug our screened and scored report, because the actual report itself does have a comprehensive as we could find at the time of instances in which there were automated decision-making systems being utilized in some capacity. And we used automated decision-making system very broadly, but the report itself contains an entire table, and we break it up into like education, like economic opportunity, housing, public benefits generally, or unemployment, things like that. So if you want to know a little more comprehensively, there's a table right there that in our screening and scoring report.
Thank you so much.
Great. So those are all the questions that we had. I'll turn it over to Chris and Christina. Did you get any questions in the chat? I know it's been pretty robust throughout the hour.
Yeah, we do have a question, and I wonder, this is from John Blake. I wonder if you want to unmute and ask the question. Otherwise, I'm happy to read, but it's brilliant and complex.
Sure. It's late in the evening, and I'm happy to take a stab at my brain still working. I'm just wondering, I'm a consumer protections attorney in the Economic Security Unit at Neighborhood Legal Services Program. I was previously at SEDEC DC. And we spend a lot of time thinking about how are these bills going to increase our ability to help individual clients. And we talked a little bit about the AG's office and their enforcement ability, which is incredibly important. But the AG is never going to have enough resources to enforce every individual action. And so I think we all know that private enforcement, be that through public interest lawyers or even the private bar, is the way that we sort of enforce consumer protections. I shouldn't even say sort of, it is the way that we enforce consumer protections. And so, that means that private rights of action are important, as Kevin had, talked about, my colleague from Arkansas. Money is important. We're facing trouble in, bringing consumer protection claims on the basis of standing. You have to have individualized injury. DC uses, prudentially uses the standing doctrine from federal courts. So we have the problem on the state level too. And then you sort of add to that the definition of, a covered entity under the Algorithmic Fairness Bill. And, I'm sort of combining all those things together with, FCRA, the Fair Credit Reporting Act, potential federal preemption. If you have an individualized injury, you're likely going to have a FCRA claim. And so I'm just wondering, is the bill going to add any tools to, the individual, private attorneys, toolkit in trying to protect consumers in the district?
I can take a stab and then maybe turn it over to Kevin for a more nuanced view of the litigation landscape, because I think a lot of his, kind of overlay of like how the damages work do kind of apply here. But this is a very good question, and I'm not here to give anyone any excess hope about like how the Supreme Court will view standing or broadening class actions. Like, I think we all know what's going on there. The only hope I have here, and it's sort of the silver lining on a very dark cloud, is things are very, very bad in this sector, such that I think that almost any law would represent a big improvement, especially when you're getting a notice that you have been harmed by an algorithm. Like right now, it just doesn't exist, right? Like you get denied for something, you never know that an algorithm's used. And in some cases, it's really, really, really blatant, right? Like we've seen algorithms charge graduates of historically Black colleges and universities higher interest rates. Like that's not a sophisticated, like going back to Edna and Kevin's point about how, algorithms or machine learning are these like sophisticated beasts that sort of pull the wool over people's eyes. It's not that smart when you're denying people who graduated from historically Black universities or giving them higher interest rates. If individual consumers are receiving that notice that they have been scored at a higher interest rate according to this algorithm, and they know all of their fellow alumni that their peers and friends with also are, that seems like a pretty good class to me. But again, I'm not a litigator. The other thing that I would say before turn it over to Kevin for this overview is there is I know that your question is specifically about the individual, but I think that in the national privacy landscape, there is a real need for state laws that make companies do anything. around this, because right now we've seen a bunch of very weak state laws that are primarily written by lobbyists from industry that said, great, we tackled privacy, click your bubble, do your notice and choice regime, and move on. I think that anything that makes companies examine their practices and behaviors before deployment helps the national conversation and the national legislative environment, so we could get some baseline privacy protections that would stop rampant data collection and impose some data minimization concept. Some of these other things that I think will really, really help individuals, whether through direct private action enforcement or trickle down effects.
Yeah, and I'll say I can't speak to the preemption issue. I don't know that. I can say that the transparency requirements in the proposed DC bill may end up being helpful, because kind of to Enid's point about machine learning, a lot of times the programmers can't even explain how a true machine learning program generates an outcome. Like it's making associations between variables that no one has told it to make. This is an idea I've thought about more in the context of due process with respect to government agencies. But if you can embed essentially a due process like concept in statutory notice requirements, you might get here, which is that perhaps procedural due process provides a sort of a substantive limit on the complexity of the decision-making process, right? You can end up having a decision-making process so complex that it can't be explained in ways that are intelligible to the person who has the decision made about them. So that may be some hope in that DC bill if the transparency requirements and explainability requirements are significant and people are being subject to algorithms that folks can't explain. Maybe you have something there, and maybe that's a cause of action that comes with damages and can be made into a class or injunctive relief or whatever it is that's appropriate there.
Yeah, that's one of the things that kind of seems so odd to me, is that if you don't really understand the full process of what you're challenging, how is there not just an obvious due process? You're just laughing at my. Do you mind, Kevin? Do you mind touching on that? I mean, obviously you litigated that case, so would you mind touching on explaining to me why? What is the reasoning for not?
I mean, so much look, so many courts are harsh, are unsympathetic to poor people. So many people don't have any experience of what it's like to get a notice that doesn't tell you anything, or to go through administrative hearing processes that really are kind of kangaroo courts. Even though I practice in them, I'm not putting them down as sort of a legitimate venue, but how they're run. So yes, I mean, due process is this wonderful concept, but it's oftentimes read restrictively without, real sympathy for what it means. So if you wanted to bring that case, you would want readability experts, you'd want, you could kind of build a really sophisticated due process case. But yeah, no, it's sad. And so in my circumstance, we had, again, notice and ascertainable standards. And my dumbass, so I told the judge I figured out how the algorithm worked. And he looked and he said, and so, his concern, so how can I phrase this? If we won on ascertainable standards, maybe the agency would have had to publish how the algorithm works or something, that might be accessible. The judge said, no, I'm not worried about that because our notice requirements are such that they should have to be able to put these in plain terms, but within some limitations, right? And then you get into what's reasonable for to expect of state agencies and practical considerations. So that's why, Barty, I mean, I think, yes, I believe in a robust, concept of due process. I think practically translating that into positive outcomes for our clients ends up being really tough in many situations.
Thank you. One of the things that you mentioned earlier, and either Anid or Alex, you could answer this. One of the things was about where to pull data from. So I noticed I forget if it was either the EPIC report or the testimony from Upturn, but there's this discussion about some of these record sealing legislation in DC and how that might benefit people. Do you think that there's anything that we could do in DC, or there's any laws pending or or anything like that that could help protect people's rights when it comes to employment or housing?
I could tackle it a little bit in the broad sense of we need to minimize our data collection generally so that they wouldn't be pooling this sort of data. And also when you're building a system, you may not always use all these factors. Like in, for example, certain like public benefits algorithms, sometimes it just doesn't make sense that you're using certain factors about family members or how distance traveled or where you're buying certain things to kind of determine random things like fraud. Like how are some of these factors relevant? And so I think that's one question is like, one, don't collect as much data generally, broadly speaking. And then two, when you're making and training an algorithm, trying to determine what is the most important factors you're calculating, because some factors just are inherently really biased and discriminatory when you're thinking about weights and when you're creating a risk score and things like that. So it's like a two-pronged thing.
Right. Relevancy too. So
yeah,
Kevin,
it's
for
like
instance,
what?
sorry. Go ahead.
No,
Sorry.
I was just saying, it's just like I was just like compounding about like why would certain factors be relevant to determining this type of score, or why would you think that this is a form of fraud or something like that?
I was going to shoot it to Kevin to say for home health care analysis for the assessment tool, asking a question like, do you have a family member that can assist you, and factoring it into the score is just kind of contrary to the whole idea of encapsulating someone's health needs.
Yeah, exactly. And there's a whole host of things that they ask you, right? Like there's the Inter-RAI home care assessment that's being used in DC as a standard has 280 questions. The algorithm called RUGS that pairs with that assessment tool never uses more than 60 of those questions in its determination. And even those 60 are sort of in different constellations, right? Where sometimes they matter in one particular way and don't in others. So you're asking at least 220 questions that don't matter. And you're forcing somebody to endure an hour, 2 hours of assessment, super invasive. God knows what else they're doing with the data. That was Inter-RAI's condition. They like license you that. They license you the tool and maybe for payment, but they definitely want all the data, right? De-identified so that then they can go and do different norms and everything else to build something else. So yes, I mean, hopefully that answers your question, Barty. I'm sorry, I'm losing the thread here.
No, it's just
My bad.
to me, it never made sense to me to have people on nursing home or determining nursing home level of care, and then you have a 286 question assessment when you only utilize a certain amount of them. I mean, just using that setup, doesn't it kind of just cause confusion and fatigue for that person to be able to answer accurately?
Yeah, and if any of you out there watching have the chance, go to an actual assessment, watch what the assessor does, how they ask the question, watch how they translate the person's answer into a score, and then watch how your client or the person proceeds during the course of the assessment. And, you know, if you're asked a whole bunch of questions that have really fine parsing of like, do you need moderate assistance, minimal assistance, total dependence, maximal assistance, right? Like you just get tired of answering these questions for an hour and a half, 2 hours. And then there's all the other human aspects of like wanting to emphasize what you can do, because if you think about what you can do, it can be pretty shitty and depressing, right? So there's a whole host of things just with the assessment process in a situation like that, getting the information that you're plugging into the algorithm that definitely don't feel fair, reasoned, appropriate in any sense of the words.
Exactly. Yeah, and it's also, I didn't even think about the concept that they could be utilizing those extra questions to perhaps even sell that data, and we don't even know the answer to that question and what they're doing with it. Sebastian, did you want to do a wrap up? I don't know if, did anybody else have any other questions? We'd love to field some in the chat if anybody had one, or if you want to just come off mute and ask anything that you're dying to get off your chest. We'd love to hear any commentary.
All right. If not, I'll go ahead and turn it over to Christina to wrap up our event.